the life of a bail bondsman.
Out free on multiple felony bonds or PR bonds.
Nationwide movement for police and criminal justice reform.
For this bond issue, repeat violent offenders.
Bail talk, we talk bail. Bail talk, we talk bail. Bail talk, we talk bail. Bail City, Red Room, bail talk, we talk bail.
Welcome to another episode of Bail Talk. I'm here with my co-host. My name's Carter Spencieri. We have a special guest. I'll introduce him in a second. I'm here with...
I'm Mark Spencieri from Express Bail Bonds.
Nicholas Sanchez, fugitive recovery agent for Bail City Bail Bonds.
And Shane came on and helped me out here. One of my guys that was going to come on, he couldn't make it tonight, and he saved my butt tonight. So we have a guest here. Shane, I'll let you go ahead and kind of introduce yourself and tell us about how you got in the business.
Well, my name is Shane Rolf. My company, my bail bond company, is based in suburban Kansas City. We're on the Kansas side, so mostly Johnson County, but we also do Wyandotte County. I've been writing bonds for about 36 years now. I'm also the executive vice president of the Kansas Bail Agents Association, and I've been in that post for a long, long time. We've had several presidents come and go, and I've always been the executive vice president. So I'm more than happy to work in that role as opposed to have to, massage everybody's egos like the president has to do. My introduction into the bail bonds really came as a family type of operation. It wasn't a family company, but my mother was involved with the people that helped set the company up, and they needed somebody to operate it. And, you sit back and go, well, I should have gone to law school, or I should have done something else. But at the time I didn't have the patience for it. And so I've been writing bonds since I was 20 years old. And it's worked out well for us over the years, but there's always challenges.
Wow. That's a long time. Almost the same as my uncle here.
Yeah, I started in 1988, 20 years old as well.
And, you guys are doing a podcast. Is it Bail in the Midwest podcast, right?
Yeah, that's correct. And we've done 4 episodes of the Bail in the Midwest podcast so far. And most of what we focused on right now are arguments about bail reform, the pros and, well, not a whole lot of pros, but mostly the cons. And some of the results that have occurred from that, and the arguments. The last one we spent was arguments for bail reform, and then how those arguments actually stacked up or didn't stack up when you look at real world activities surrounding that.
Yeah, I tuned into a couple episodes. I really enjoyed listening to you guys. How important do you think it is that bondsmen in other states should maybe try to do stuff like that, to kind of tell the community and the public, what we really do, so that when, someday when this comes to the House or a vote maybe or something, then they actually know our importance and exactly what we do?
Oh, it's very important. If you look at, I think it was a second episode podcast, I did an interview with Gerald Madrid from New Mexico. And New Mexico bondsmen are really suffering. I mean, they're functionally out of business for a long time, and if you don't get out across what you do and how we're important and how we affect the criminal justice system, and how important it is what we do, to making sure people show up for court, making sure justice is served, making sure that bail is used as part of the overall deterrence program to keep people out of trouble and not getting arrested again. But also at the same time, not clogging up the jails to where it costs, tens of millions of dollars to keep somebody in custody on a preventive detention basis. And, most of those arguments about whether or not you're presumed innocent, go fly out the window when you're dealing with preventive detention. So you have to find a balance. And it's important for us to try and tell people what we do, because most of these things, the law swings like a pendulum. You have ultra harsh on one side and ultra lenient on the other side. Bail tends to be in the middle. And as we've seen from the polarizing aspect of our politics, the middle is not always the best ground to be. And so it's kind of hard to make that argument for the middle ground. Well, and especially when you deal with people on Facebook and other social media, well, this guy's out of jail, why was he in custody, or why wasn't he locked up? Well, we should lock everybody up. And then you have the other side, well, we should let everybody go. Well, bail's trying to find a balance in there, and that can be really difficult to do, particularly in a polarized environment.
Have you guys experienced quite a bit of bills coming through and other bail reform stuff in the last 5-10 years in Kansas?
Oh, absolutely. And it's been different county to county. The biggest challenge we probably faced was in the last 2 years, the Kansas Supreme Court ordered what they called a pretrial justice task force to look at all the different aspects of pretrial release and the best way to handle that. And I really do think, I mean, it's a 180-page long book, and the hearings lasted for a year and a half, and we attended every single one of those hearings. At least one of our members was there. I was there for 90% of those hearings. We gave some testimony. Jeff Clayton, who I interviewed before, he came in and gave testimony as well. But a whole host of anti-bail people came in and gave testimony as well. And the Pretrial Justice Institute, basically took out all the members of the task force and wined and dined them and told them about how great things were that they were doing. And the people from the Bail Project came in and talked to them. And I really do think that Kansas was on the verge of adopting a pretrial risk assessment algorithm that they were going to use, except right as they were getting ready to issue their report. And I mentioned this in my last podcast, the Pretrial Justice Institute backed away from using algorithms because the ACLU and certain other groups decided that those algorithms had a racist content to them. And so they didn't want to be seen as being racist in what they were advocating. So they completely backed away from using a pretrial risk assessment as an algorithm to decide how to, which people to let go. And it really kind of threw our pretrial justice task force for a loop because they didn't really know what to do after that. So they came up with a bunch of different suggestions and then just kind of threw them out and then put it in the book and go, oh, here, legislature, maybe you can do this. And one bill got introduced, and they wanted to expand the use of pretrial release agencies, because in Kansas, only an actual court services officer, which is a statutorily defined position, can actually do pretrial supervision for the state. And there are several counties that have their own non-court services people that are sort of doing what we loosely refer to as bond supervision, basically drug testing and things along those lines. And so they wanted to expand that. But at the same time, what they were trying to do was enhance the judicial branch budget. So they tried to combine two different things where they wanted to expand the number of places or people that could do pretrial supervision to beyond just court services officers, and also a way to enhance their budget because all the money that was supposed to generate didn't go back in the judicial branch budget. And since they overreached on that, basically the bill died. And so we haven't heard anything more from that. And I don't anticipate a whole lot of pushback. I think what we're getting is more backdoor stuff because we're seeing a lot more use of signature bonds here than we were before. One county over, they've pretty much stopped using bonds altogether and just turn around and revolving door people. There hasn't been a change, but the judges there have just decided, well, we're just going to what we call PR. I know most places refer to as own recognizance. Here, which generally referred to as personal recognizance, but they're basically PRing everybody that comes through. And we're seeing a lot more of that in my county, which is disturbing because they hired the same criminal justice coordinator that was working in the county that did away with all their bondsmen. And so there's some pushback there. I don't think our judges are sold on it, and we're right on the state line as well, to where people on misdemeanors can just go back to Kansas City, Missouri, and they're home free unless there's somebody, making sure they show back up from across state lines. We've gotten it. Every county is a little different on how they handle it. So, I mean, there's 105 counties in Kansas and 31 judicial districts. They all handle their bail bond situation just a little bit differently. We're not under incredible pressure right now, but you can see it sort of pushing that direction. So you got to be able to push back.
This is Mark, and I had a question. It sounds like you guys maybe are 5 to 7 years behind us, because this started several years ago for us, and you mentioned the guy from New Mexico. I think New Mexico and Colorado have insane amount of criminal. Colorado's #1 in the nation for auto theft, and number one for bank robbery now. And they did it like the way you're describing. Maybe you can tell me if you feel different, but they start with, one county kind of is doing the personal reconnaissance, own reconnaissance, and then they get it to another county, and then it kind of just grows like a cancer, and the crime goes. It sounds like you guys have some reasonable bail still going, but it's trying to creep in. Can you tell me if you feel like I'm right on that, or how far along are you guys into that process where they're trying to creep in?
Well, Kansas is a little bit different than Colorado in we only have a few small pockets of what you'd call blue cities. So it's a largely conservative Republican state. And so like the next county over from me is Douglas County, which is where the University of Kansas is. And that's one of those liberal hotspots. And so they're busy trying to let everybody go. But I think some of our pushback on that is that, crime is increasing, and, the pretrial justice task force did not want to do away with bond altogether, but they did buy into the whole equal protection. And if you can't afford bond, we need to look at those things. But there absolutely has been no attempt to change the Constitution like they did in New Mexico and New Jersey. So, I mean, there is the push, but I don't think it's going as poorly as it did in Colorado. You probably remember the guy's name that really advocated for that. I can't remember. Is it Schneike, Tim Schneike, something like that? He was based out of Colorado, and was actually advocated for a lot of the changes that were made or in the Denver area. And then, of course, that was one of the things we pointed out, in our own criminal justice task force was in Colorado, they were supposed to save all this money, save all this space. And within, 3 months after adopting this program, they had to open up a shuttered jail to hold all the people in custody. So,
yeah, we're also, I read something on the way here. I mean, we're top 5 or top 8 or something for fentanyl overdoses. And you see, they call the signature bonds PR bonds here as well.
Oh,
they
okay.
go by
All
PR bonds. I know some states are OR as well. Auto theft is getting a PR bond. Most drug cases, possession is getting a PR bond. We've seen some sexual assault cases get PR bonds, believe it or not.
Oh, a lot of them.
And it's crazy. That's why we kind of started this show, just because things were getting, so out of hand. How important do you think, all these bondsmen trying to come together, associations, state associations, PBUS, all these other people coming together to try and fight these people? I think right now we're at that point where we got to all come together and start fighting.
Yeah, and having some outside help along with bondsmen need to all be on the same page. I mean, I know that we're all type A personalities and we're all competitive with each other. It's direct competition, and we can carry grudges for a long time. But our main competition is not each other. Our main competition is that judge or that pretrial release agency that wants to take all of our people away from us. That they want to turn around and let everybody go without requiring any sort of, security to make sure they show back the report. That's our competition. I mean, yeah, that guy across the street, he's going to steal a bond from you every now and then, and you're going to steal one from him, or you're going to offer a better deal. I guess steal is probably not the best way to say that, but you're going to offer a better deal to somebody. He's going to offer a better deal to somebody else. But in the end, you're still able to offer those better deals and still, post bonds. When the courts turn around and let everybody go, there's nobody to post bond for. So, I guarantee you that there are several bondsmen that I compete with that I'm not the best of friends with and have been problems and thorns in my side for years. But, the important thing is, we can continue to be thorns in each other's sides. If you go to a New Mexico type situation, or you go to a Douglas County situation where they let everybody go, everybody's going to have to find different jobs to do. And, then we live in these same communities. We're going to suffer the same effects of this increased crime rate as everybody else. If you can or if you can get other people involved that, and point out these crime things, because sadly, what's going to happen on these things is you're going to have some horrible tragedy where people are going to die, killed by somebody who's released with absolutely nothing. And we're seeing it all across the country. And you're going to get some pushback from, finally the news media is going to think, oh, wow, well, there's a story here. The if it bleeds, it leads kind of story. I mean, that's the same reason why California backed off their latest incarnation of bail reform, is because there was a horrific, quadruple murder of a family in a park by somebody that was out on a zero bond. And so, you hate for that to happen, but I mean, that's always going to happen in these circumstances. And it just happens more often when you're not providing any sort of security, any sort of filter to make sure people show back up for court and that the members of their community support network are involved in their release.
Did COVID was probably different for all the different states and bail bonds. Something we experienced here was they weren't starting to take some crimes, or we would, someone would miss court. We'd try and bring them back and they'd say, no, we can't take them. And the bonds dramatically lowered because they didn't want people incarcerated during that time. Did you guys see anything like that in your neck of the woods?
Oh, absolutely. And, this for several months, all of Johnson County is a suburban community. And so there's the county itself, and then there's 17 different little bedroom communities that are all suburbs of Kansas City. So they each have their own police department and their own court system. For the longest time, none of those cities were taking people in to custody. If we had to bring somebody in who'd missed court, they'd still go, hey, your guy didn't show up for court, you need to get him back or pay. You'd bring them back in and they'd turn around and do an advise and release and just turn around and let them right back out the door after you brought them back in. But the county itself, one of the features that Johnson County has and Kansas has is their community corrections program, which is basically a halfway house. And I'm sure there are places in Colorado that have similar deals. They basically emptied out these halfway houses, the residential center. But they had all these people that were employed there that they didn't want to fire because they figured they'd need them at some point in time. So they took like a couple wings of the residential center and converted it into what they call problem-solving beds. So people who didn't have a place to live. And so it started off that they would PR people to these problem-solving beds. And these people would just get out and walk away, because they could leave the problem-solving bed and go to work and stuff. They just leave. And so now people are going to problem-solving bed, although it's supposed to be for homeless and indigent people, they're still making them post a bond because it wasn't working out when they just sent them out there without anything to guarantee the bond. But yeah, they've completely converted what used to be a completely full residential center. There used to be like a week-long wait to get an open bed at that center if you were assigned there as part of your probation. But because they've gone completely lenient, and that's another problem if you're, a bail aside, if you're not going to enforce the laws that are there, you're going to have more people break them. I think it was one of the people I listened to talk about the transactional cost of committing a crime. If all I'm going to do is, get a slap on the wrist and be put on probation, that's not a deterrent. If I don't have to call my parents and come make, them be the ones to come get me out of jail, why would I not do this? So, but yeah, there's been great fundamental changes in how COVID has affected us. They cleared out the jail dropped, at least 40% of its population. Now it's built back up now because, what happens is if you let everybody go and, 50% of them don't show up for court. Well, fortunately, we haven't gotten into the complete revolving door aspect of things where you pick them up and they turn around and, they issue bench warrants with signature bonds. Although I've seen some of those. We had a girl we just picked up a week ago. We had to pay off the bond. We picked her up like a week later and surrendered her. She sat in custody for a week. They turned around and gave her a signature bond. It's like, she's not coming back. We had to, which I don't want to get into story mode, but she was a problem person getting back in. And they turned around and just let her go after she sat in custody for a week and shipped her off to another warrant she had in another jurisdiction. She won't be back. We'll be circling this back around again.
Yeah, we have that problem too. We'll bring someone back in. It's second, third failure to appear. And then somehow they get a PR bond. And then not only that, but in Denver, they had started doing a $1 bond. which is kind of crazy what I thought, don't you think?
Oh, yeah, they do the $1 bonds. I've seen people get a personal recognizance warrant, so they get caught, and then they write the personal recognizance bond and release them. And that's happened, their third failed to appear. And it could be DUIs, which, there's a potential to hurt people, drunk driving, even felonies, auto theft. And it's kind of a catch and release policy. And they'll do it 3 different fail to appears. We've had the judicial system try to come and legally eliminate us. But what has happened here the last several years is our lawmakers sent the judges a note, a letter, to use the least amount of bail as necessary. And so they've effectively, with a letter, just reduced the bail down to ridiculous, where $1,000 bond would be identity theft, a stolen car, drug possession of numerous, whatever, small amounts to large amounts, resisting arrest, eluding the police, a high-speed chase. And it's $1,000 bond. And I've seen it for other charges, robberies. It's kind of ridiculous, all the crime that's involved in $1,000 bond, in my opinion.
Well, absolutely. And I know one of the things that they argue, there was a study that was done, 20 years ago that looked at the amount of bonds and how that impacted appearance. And the study showed, just one single study, but it keeps getting brought back up again, that once the bond got past $2,500, the amount of the bond didn't seem to really have a whole lot of impact on the appearance rate. Now, I sort of disagree with that. And it was just this one study that was done, and it gets referred back to over and over and over again as the reason why we can go with even a low bond. But yeah, the dollar bonds, that's just a way to say that we require to buy. In all honesty, that doesn't give the courts as much cover or, CYA aspect of things as, a $10,000 signature bond. Well, if we posted a $10,000 bond, and when the news reports on this guy that was out on a $10,000 bond, well, they don't look as bad as if they were out on a $1 bond, even though the $1 was actually, $1 more than they had to put up for the $10,000 bond. And that's one of the things we've explored here is putting some limitations legislatively on who's eligible for signature bonds. What sort of restrictions can we put in place to where the courts can't give signature bonds in certain instances? Now, obviously, the courts don't like that, and they push back on that pretty hard, because argue that they're taking their discretion away. But the problem is, if you were successful in doing that, nothing's going to stop them from setting a bond at $1 or $2 or whatever, some ridiculously low amount that's functionally the same as a signature bond.
Have you guys had any of they set a $25,000 bond and you can pay 10% to the courts? Have you had any of that happen out there?
In the state capital, Topeka, which is Shawnee County, did that all on their own, and they ran with it for 15 years. What's referred to in Kansas as ORCD, because it's OR cash deposit. So theoretically, it's your 10% cash deposit, and the other 90% is secured by an OR bond, which is meaningless. As we started to coalesce as an organization that was active legislatively, it kind of had its birthplace out of Shawnee County in pushing back on that ORCD program. So what Kansas has now, you still have where you can, in certain instances, use a 10% bond. However, it can't be done on a bond that's larger than $2,500. It can't be given to someone who's failed to appear. It can't be used for a probation violation or a fugitive from justice charge. And it can't be used for anything more serious. Kansas has a sentencing grid. Then a level 7, I think, is the top. The 1 through 10 is our sentencing grid. So anything higher than level 7, it can't be used for that. And you can't have more than a criminal history H, which is at least 1 felony conviction. And it can't be a person there. Anyway, there's a whole list of restrictions on who can't use those bonds. And other than a couple of counties that were using them originally, they're not real common. Certainly not as common as Shawnee County used to be. And one thing, that Shawnee County went from 15,000 outstanding warrants to 3 years after they did away with that program, largely they were down to 5,000 outstanding warrants. So, I mean, it's a tough argument for them to make that, oh, well, this other thing was working great because we generated $1.5 million worth of revenue that we could use towards fines and costs and stuff. If you've got an additional 10,000 warrants floating out for people that don't show up for court. But yeah, the 10% bond is used to a certain extent here, but not widely.
So it was effectively a $250 bond. They only paid $250 to get out. And could that be like a domestic violence, DUI, that kind of thing, a fresh charge?
It could be, yes. But again, there are several filters where you can't qualify for that. You have to be an in-state resident. You can't have any prior failure peers on your record. There's a whole list of things that they're supposed to follow. Now, every now and then you'll see somebody slip through, and they'll give one that that falls outside those parameters, and then you have to decide, well, do I go, say something to somebody and get them all worked up at me, or do I just let this one go if they're not doing it on a regular basis?
So we used to have rules and regulations for a PR bond. The prior fail to appears were a problem with that. Logical things. It sounds like you guys still have some of that. And then it got to a point where if you had a pulse, I think you qualified for a PR bond at this point. What's interesting is, Denver has done this thing with letting everybody go, and then they flipped all the way over to cash. And Jefferson County is kind of another one. I think George Soros funded that district attorney, where they'll do a cash-only bond of $30,000 or $50,000. And we're, as bail bondsmen, a legal method of posting bail by state law, yet they've excluded us. And we're not talking about cases with 5 failed to appears for their trial date. These are new charges, and they just effectively say you can't use a bondsman. So, felony menacing, second-degree assault, $25,000 is a reasonable bail, but why can't you pay the bail bondsman the percentage if that's your choice? Because who has $25,000 or $50,000 cash? It's got to be a smaller amount of the population, in my opinion.
Well, that's correct. And it depends on your state and how the state Supreme Court has interpreted what, sufficient surety means, because you'll have some states that say, well, yeah, a cash only bond, counts as a surety bond. It's like, well, no, it doesn't. And then other states will specifically say, no, once the court has set the amount of bond, it's up to the defendant to choose the method of that, whether it's a surety bond or a full cash bond or what have you. Kansas is one of those states that, the Constitution still reflects that you shall be bailable by sufficient solvent sureties, except in capital crimes. One of the things that we as an association were able to do was put the language into the statute that you cannot exclude the ability to use a surety bond. So by statute, you cannot set a cash only bond in Kansas. The language is sort of tweaked in there, but basically says that, the option of using paragraph number 3, which is bond by surety, cannot be denied. So except in a capital case when you can deny bond altogether, you cannot do a cash only bond. Now, that's not to say, again, that judges don't decide that they're going to do whatever they want to do. But the statute itself does not allow for a cash only bond. So, and again, the restrictions I was talking about for what we called the ORCD bond, the 10% bond, those are restrictions that are in statute as well. So, I mean, theoretically, they're supposed to follow the statute when they're setting those bonds. So, as opposed to just guidelines or anything along those lines, if you can get the statutory language in place, you're usually pretty good. It was kind of funny because during the pretrial justice task force, they were pushing the argument of cash only bonds until I pointed out that, but the statute doesn't allow for that. And then they're like, oh shit, and go back and look at the statute again. I guess it doesn't, which is sort of something I was proud of because I actually wrote that passage of the statute that's there, so that we managed to get put through. So that's worked out well for us, because there would have been a lot of places that strictly went, okay, we're just going to do cash only bonds, and you bondsmen can get out and we'll set these bonds at $1,000 cash only and buy. So we've done a good job in Kansas legislatively. But I mean, there's always, you're dealing with judges and lawyers, and there's always a loophole they can work your way through. So you have to be really, really careful about what you do and that you don't alienate them too much But you also have to be, ultra friendly with your legislators as best you can and point out the important things that you do. And, if you guys have the money to hire a lobbyist that works up there, I, absolutely suggest doing that. Try and get involved in anything that legislatures are involved in. Try and do that. It is bail bonds, unfortunately, is a political line of work these days. It's become a real football between the left and the right on that, as far as what bail should and shouldn't be. And so we've got to pick a side and argue the best that we can.
Yeah, I think your state has some pretty good laws, in my opinion. Colorado's very left of you guys, and we are always on the defense of a law that's trying to eliminate us. And so trying to pass something, I think we've had a few things that have tried to pass that would actually help us, and it gets shot down because Colorado's probably 60% left, liberal, maybe more, probably more on the lawmaker side. And so we're always just trying to defend ourselves. At this point, crime is so bad. At the last hearing they had, there were people, business owners, Boulder's a liberal part, kind of like a Denver elite. And there were business owners talking about their employees being harassed, assaulted, kind of mugged, afraid to go to their cars. There were some municipal judges talking about the problem with crime, chief of police, sheriffs. And, of course, there was a few that the left, either they just have their ideology or they've, persuaded them to go that way. But Colorado does have so much crime that there are people awake, and it stopped the last one. But for us to get a positive law like you guys have, your laws sound pretty good to me. If we had some of that, I would be pretty happy, to be honest with you. And hopefully you guys can, keep that away. It sounds like they're trying to get their foot in the door, but nationally and New Mexico, like you talked as Gerald, and our law, the crime is so bad that it's just clear. And you guys are probably getting a small taste of it with the little, things they're trying. So hopefully you guys can stave that off. We have to come back around for correction, in my opinion.
Well, and it's tough to do it if you can like incrementally work your way back up, to where it's not something they really want to kill you over. Well, gosh, you don't want to give signature bond to these murderers, do you? Or these rapists. And then if you can, we have not been successful in doing that. We've tried to, okay, well let's create a scenario. Okay, these things are excluded from being signature bonds, with the idea that we could then come back in later sessions, go, well, yeah, but you want to exclude these additional things too, right? To where you've created a scenario where you can't give a signature bond on these types of charges, and then maybe you can look at expanding that particular list of what those charges are. Again, it is as much work as we've done. We haven't been able to get that through either yet. So you do get a huge amount of pushback from the courts. And, as much as I hate to say it, legislators are going to look at them far better than they're going to look at us. They're a judge, they're a black robe, they know what they're doing, they're lawyers, and they come in and tell you how great things are. And we come and go, no, things aren't great. Well, the judge says they are. And they'll come up with some far-fetched reason why what they want to do has good reason. I had a judge come in and say that I was lying to the legislature when I'd gone through the entire docket and listed out the failure to appear rate for these types of bonds. Well, we looked through the whole thing and there were only 2 failures to appear. It's like, I've got 500 pages I just submitted into the record. That's a list of all these cases that are failures to appear. You can't exactly say that I'm lying, but they were more than happy to do that.
Is there any kind of bail schedule out there that they go by or look at?
There is no statewide bail schedule. In my county, the only bail schedule is for traffic offenses who've just been arrested. Now, some of the cities do have those bail schedules, but we've gotten to a point, particularly since COVID, that the only municipal bonds we're doing are failure to appear bonds. Now, from one perspective. Fortunately, there's enough failure to appears that there's plenty of bonds, second time around on that. But most places, most places where I work do not have a bond schedule. The judge actually has to see the defendant and make a decision about the bond amount. I know that in Wichita, they do have what they call hold for state warrant, and that's a pre-charging bond schedule that you can post bond for. I've always questioned, quite frankly, how that works, but it's a pre-charging bond you can post, and then if they get you charged within a couple of weeks, then that rolls over to your actual controlling bond. Otherwise, you can sit out your 48 hours until the case is, until they decide to actually charge you or not charge you.
Do you guys have the no bond for domestic violences, or is there a bond set?
Oh, there's always a bond set. In Johnson County, in my county, one of the judges who's since retired, but basically was one of the pioneers of the domestic violence court, to where they were focused strictly on domestic violence. So we have one judge that deals with misdemeanor domestic violence, and that's all he deals with, and another judge that handles both felony domestic violence and the veterans court that they have here. But what they do is they'll have the victim, you get arrested for domestic violence case, you'll have court set the following day, but the victim in the crime will be given sort of a pseudo notice to appear, which is not really a notice to appear, but hey, come in and visit with our victim witness people at like noon, and they go to court at 2:30, and then those victims can have some input on what they want to have happen as far as the bond. Do they want to be able to have contact with that person? But probably 90% of the people on domestic violence, particularly on misdemeanor domestic violence, unless you have priors, they're given signature bonds straight out of the bag. And then, along with some sort of no contact order. Now, sometimes those people will be back 2 days later for a violation protection order, but, a lot of times it was something that probably wouldn't have been charged in most jurisdictions. The police show up and break things up, separate up. But Johnson County has a program where if the police are called and they have any indication that there was a domestic violence going on, the alleged victim does not actually have to sign a complaint. So they can just arrest somebody based upon officers' intuition on that, and then charge them the following day, kick them out of the house, you can't go back home, what have you. Whether the victim actually wants that to occur or not, even if the victim wasn't the one who called. You're in an apartment complex and people are throwing plates at each other, and the neighbor calls and you show up, well, somebody's going to jail for that. But most of those people do get signature bonds unless they have a pretty extensive history.
So you do have a see a judge policy out there. I agree domestic violence is a problem. We have a city here, Aurora, which is Metro Denver area, and they'll have a municipal domestic with a $2,000 bond. And I think there's a few other cities that are kind of doing similar things, but not many, where, you're going to get booked in, you have some time to chill out, to think about what's going on, but you can post the bond, for $300 and get back to work. And we have people with, a dog locked in their house or whatever. I think that's kind of reasonable, unless it's a violent charge, a little arguing, pushing and shoving. $2,000 bond, you got the restraining order, and court's usually the next day, so the judge can go over the rules again, and you'll get the violation of a protection order if there's contact. But to me, for minor offenses, this whole overnight thing, and then if it's a weekend, Friday night or too late Thursday where you don't see the judge Friday, you sit till Monday. Colorado actually, I think, passed a law where you have to be advised, I think, within 48 hours, which is a little better. But can you imagine, Thursday night, you don't get booked in time to see the judge Friday, Monday's a holiday, you're in jail for, 4 days or so over an argument? That's not acceptable. And I think that $2,000 bond, or even make it $5,000, is reasonable, where the person has the option, but they can sit and try to get the personal recognizance bond. But some people's lives will be wrecked sitting a day or 2 or 4, in my opinion. So,
got to be careful with that argument too, because that's the same argument people that don't want any bail at all will argue, that you're wrecking lives by making people post bond or setting a bond that these people can't afford. It's not just that. There still needs to be the public safety aspect of it. Sometimes that cooling off period helps yeah, it could cost you your job. Generally, that's not going to happen over the course of 1 or 2 days. It obviously depends on the job. But 48 hours, I think if they're holding them longer than that, they probably have some Supreme Court arguments as far as, you need to get somebody charged and a bond set within 48 hours, or, do something with them as opposed to leave them there just in limbo.
Yeah, that law just, I think, happened recently where judges are coming in Saturdays, and if there's a holiday,
Magistrates, yeah, they've
magistrate Sundays if there's a holiday, Monday maybe.
Which kind of, in a way, is a public safety hazard, because I see a lot of low bonds going on the weekends because the magistrates just started this. They don't have much experience, I don't think, in setting the bail. So it's kind of hard to gauge, I believe, for them what it should be or what the average, So, we've been seeing, sex assault on a minor, $5,000 bond on one of those weekends, and then, the rest of the docket PRs.
Right.
So I think that it's a good idea, because then they can, get these people out, get them in and out of the courts. But I think it also there's a public safety issue here. We got to get a little more time under their belt setting bail. And I think that a bail schedule, something to go off of, it says, okay, this is a $1,000 bond, $5,000. This is could be this, but use your discretion.
Right.
Something like that would be really effective. And then there's a way to gauge that, for them.
Yeah, you've got to be careful with those two, because then you kind of open your courts up to, claims of discrimination when you use a bail schedule. I mean, a lot of the attacks we've seen from things like EJUL or they changed their name. It's, Civic something or other, but same people. Those have been attacks on bail schedules. The bail schedules are unconstitutional. Now, they've lost all those ultimately, but it's a long time down the road, and you're trying to change the philosophy there to where they let people go. But a bond schedule that's written in stone, obviously you need to have the judge be able to make some discretion, but then the argument is, what factors are they using for their discretion, and how mechanical do you make that bond schedule? Is it, okay, well, you've had a domestic violence charge, your bond's $1,000, unless you have, this, and this, and that takes you up 3 steps, or if not, it drops you down 3 steps on that sort of thing. You don't want to get in a situation where, well, this black guy has $1,000 bond on the schedule, but we set his bond at $2,500, and the white guy got a $500 bond. You don't want to have those situations where, challenges to there's some racial bias in bond setting can be made along those lines if you can choose it. And then if it's completely rigid, then you have bias that you're not actually using your discretion. And so this one guy that has 10 priors, he's got a $1,000 bond for the same charge as this guy who's never been in trouble before. So I think a lot of times judges don't like to get themselves, locked down into a bail schedule, because they, if a judge just makes a decision up out of thin air, the Court of Appeals is going to go, the judge probably had a point in setting this bond. But if they deviate from a particular schedule, then there's got to be some rules about how they're supposed to deviate from that schedule. Kansas has a sentencing guideline along those same lines. Everything's in a gridded box. And so you can go up and down and sideways on that grid, but you have to justify why you're moving outside of that range. And I don't know that the judges would want to do that for bond setting, particularly not, the larger your jurisdiction gets and you're seeing, 25 people in half an hour. I don't know that you're going to go through that whole, scenario of setting all that out without, a lawyer involved or somebody else.
Is fentanyl is a huge problem here. I don't know if it is in Kansas. You can comment on that, but the second part to that was people with getting caught with possession of fentanyl or other hardcore drugs. Are you seeing any kind of surety bonds on those, or are you seeing a lot of PR bonds?
Almost always surety bonds, but they tend to be lower. What we've seen here in the last few months is those bonds are at that $2,500 range. and we're seeing a lot more fentanyl cases come down. One of the continuing education, one of the segments in our continuing education, we've had someone come out from Narcan and give a presentation on how to use Narcan. So if you're, out picking someone up, or if you're having some sort of involvement with someone and somehow you're exposed to fentanyl, they're pushing, that you probably should have some Narcan on site. But yeah, we're seeing a lot more fentanyl cases coming along. This really just started picking up in the last, probably 6 months. And that may just have been a change in the classification on our charge sheets, because I think previous to that, they were just shown as opioids. And so now it has its own separate classification as fentanyl. And we're seeing that more in the charges about fentanyl versus just generic opioids. But yeah, it is increasing. And it's a dangerous drug. And it does really surprise me in these situations that they're setting bonds that low on drugs that can be minimal quantities. This can be fatal.
Speaking of that, what has been the lowest and highest bond you ever seen for any alleged crime?
There was the highest bond I've seen here was 25 years ago, and it was $7 million. In all honesty, he shouldn't have had a bond at all, because it turned out it was a capital case. And it was a triple homicide. The guy had basically scammed like 3 different women, and murdered them, but was also taking their bank cards and stuff along those lines. And his bond was $7 million. I think that's the highest one I've seen in my county. But that's obviously clearly an outlier. Murder generally is $500,000 to $1 million, depending on the type of charge it is. 2,500 is a pretty broad spectrum bond. I think when I looked at the numbers last, about 65% of all the bonds in Johnson County were set at $2,500 or less. But again, they have a domestic violence docket that runs out of the county courthouse, out of the district court, as opposed to in these various different cities, because then they have more consistency over what's happening in those domestic violence cases. But there's 2,000 domestic violence cases a year, and 3,500 criminal cases that are charged to district court, plus thousands of traffic cases on a regular basis. But yeah, probably 65% of the bonds out there are $2,500 or less. And again, it varies such a wide degree, and depending on the type of charge. You can have an aggravated burglary that has $1,000 bond, depending on whether it's a domestic violence thing, and you just, some ex-husband went back in the middle of a divorce and went back in his house to get his fishing gear out of the house. Well, now he's charged with an ag burglary because his wife was there. He wasn't supposed to be there. Well, that's a whole different thing than a home invasion robbery, which is still also an aggravated burglary. So one might have a pretty small bond with a no contact order or some sort of electronic monitoring, whereas a home invasion robbery is going to have $50,000 or $100,000 bond, depending on the scenarios around that. So I mean, they do still set pretty decent sized bonds on violent felonies, what Kansas refers to as person felonies. So if you have an ag battery or an ag assault or something along those lines, and those are felony violent cases, those do tend to have decent sized surety bonds associated with them. But a lot of your property crimes, you're seeing them drop off as far as their size and stuff, unless you have someone who's come in from out of town. So you get a credit card crew that comes in with a bunch of fake credit cards from out of town, buys a whole bunch of stuff, and then tries to turn it back in for cash. Or they go get some homeless guy to go get 50 different cell phone plans in his name, and they get caught there. So those bonds tend to be a little bit higher just because there's no connection to the area. But I mean, you're talking maybe $10,000 on those.
So Alex sent me a message. I think we've covered a few of these items he has on here. He was curious about how long do you have to recover someone on a forfeiture, and how's your forfeiture process on bonds in your state?
We did just modify that in statute. That just says when changes went into place here on July 1st, by statute, and this is a minimum of 60 days. So it used to be in Kansas, you had 10 days from the declaration of the forfeiture or the filing a motion for judgment on bond, 10 days after that filing to get the person back in. We did manage to get that extended to 60 days. So that's 60 days following the filing of the motion. Now, the filing a motion is not automatic. The state can do that when they choose. So that's up to the state to actually file that motion for judgment on bond. And then you have at least 60 days following that, filing that motion to get that person back in. Now, obviously, you can go back in and ask for more time from the judge. One of the other things that our statute has in it is that you can't pursue a motion for judgment on bond if more than 2 years' time has elapsed. So it used to be like 5 years was the cutoff for a contract. The statute of limitations was 5 years. So you get somebody that missed court on you, you couldn't get back in, but it was a long enough time that's like, oh man. And then 4 years and 9 months, they file a motion for judgment on bond. Like, I have no idea where this guy is. But that did get changed to 2 years. Part of the argument we made on that is, the purpose of bail is to make sure people show up for court. And the purpose of bond forfeiture hearings is not to just put a bunch of money in the pockets of the state, but to incentivize us to do our jobs of getting people back in court that have missed court. And if you just let that extend out for a long period of time, we're not doing our jobs, because we'll sit there and go, I got plenty of time, I can get away with this. But it also forces the state to take action relatively quick. 2 years, if you count that as relatively quick. So 60 days minimum. 2 years, after 2 years, the state can't pursue it if they haven't done so already. If the person's incarcerated anywhere within the United States, as long as you file a notice under penalty of perjury that the person is incarcerated, they can't take a judgment on you. And that's if they're incarcerated prior to judgment, not if they were incarcerated at the time they missed court. Couple of the changes we just got put into the statute now was that the state has to actually issue a warrant for the individual on their failure to appear in order to pursue a motion for judgment on bond. If they don't issue a warrant within 14 days of the failure to appear, they can't pursue a motion for judgment on bond. If they refuse to extradite from another state, that's grounds for setting aside the forfeiture if they're not doing that. Now, all of those things involve the bonding company can be taxed with the cost of bringing that person back from incarceration elsewhere. But the state has to actually try and do their part of it and bring that person back. Now, the failure to extradite only applies to felony cases. But that just went into effect here in Kansas on July 1st. So haven't had a whole lot of pushback on that yet. We'll see how that goes. I don't think anybody paid a whole lot of attention to that when it went through. But there were a few jurisdictions that, and actually they were some of the same jurisdictions that were heavily involved in the 10% bonds originally, that would just refuse to issue a warrant until the 60 days had passed. They'd file a motion for judgment on bond, sit the hearing for 60 days out. And if you got them back in, great. If you didn't, they'd issue a warrant after that, after you'd pay. It's like, wait a second. We should at least get the benefit of having that warrant outstanding there. One of the arguments we made was a public safety argument that, that person who's out there, they know they've missed court. That officer that happens to be pulling them over, if that warrant's not in the computer, they don't know that they're dealing with the fugitive. And you never know what exactly the reaction is going to be. If the officer has as much information as possible, if they come across that person, they're going to be in a much better position than if they didn't have that information. Anyway, that was a change that was made to our statute recently.
Do you guys have any remission abilities there? We have a thing where if we catch the person and turn them back in, we can ask for the money back that we've paid. So we still have an incentive to locate the defendant. We don't quit because we can try to recover it.
The statutory language is real generic. Yes, we can file a motion for remittitor and, at any time after we get the person back in and make that argument. It's completely up to the judge's discretion whether or not to do that. Some jurisdictions have it written into their policy, like a 30, 60, 90 day, descending amount of money that you get back. If you get them back, after judgment, you've paid the judgment. If you get them back 30 days after that, you'll get a 75% remit. The 60 days is a 50% remit, and the 90 days is a 25% remit. But those are policy decisions at different agencies. Statutorily, it's just open to judicial discretion, but we can make the request, yes. Johns County's gotten a lot larger than it used to be. I granted, compared to Denver, it's not particularly large, but it's 600,000 plus people now. Whereas when I first started doing this, it was 300,000, and you had 14 judges, only of which 4 handled criminal cases. And there was a cafeteria in the courthouse. You could go sit down and you talk to the judges during lunch and stuff along those. None of that happens anymore. The judges all kind of sequester themselves. They'll talk to you if you need to, but it's difficult to get in to see them. I mean, they know who you are, because most of them were practicing lawyers before they became judges, so they had some connection to you before that was an issue. But it's not nearly as congenial as it was before, early on. I mean, again, it also kind of depends on who you are and how you can, comport yourself with the courts. I mean, if you come in and look like you're somebody that the judge would be afraid to sit at a table with, they're probably not going to talk to you as much as if you come in and look like you're, in business casual or something, like you probably should be when you're in the courthouse dealing with them. But it really depends. I know that in Sedgwick County, the bondsmen there, at least the bondsmen that are part of the KBAA, have a really warm relationship with most of the judges. And they've managed to get, usually whenever we have a continuing education class in Wichita, they've got a representative from the courts there, and they generally have a representative from the Sedgwick County Sheriff's Office that comes and presents at our continuing education class. So it really does vary from jurisdiction to jurisdiction. I'd say Sedgwick County probably has the best relationship with their bonding companies. Johnson County is sort of ambivalent. City of Kansas City, Kansas, which is north of me, a part of Wyandotte County, is actively hostile at different times. Not so much, in the sheriff's office, but when you're out trying to pick people up in that particular city, they very much take you can't be here, or we're going to arrest you for trespassing. Like, dude, I'm on the street. I'm just watching this house. This is not trespassing. Well, you need to leave. Like, yeah, our policy says you have to leave. Anyway, so that there's been a lot of pushback back and forth on that. And you get that in every jurisdiction at some point or another, depending what officers you're dealing with.
So if you have a violent criminal, substantial warrants, some of them will come help and assist or keep it safe, that type of thing.
Yeah, and particularly if there's an active warrant, the question then becomes, they'll generally come out, but it also depends whether they'll help you or whether they'll do it themselves. Yeah. We know about this deal. We'll go knock on this door and you go wait over there. It's rare to see a combined operation, I guess you might call it, anymore. Most police departments in our area have policies against that. We have a statute that we have to check in with the police before we go, try and pick somebody up so they know we're there. But the statute says the police may accompany the bondsman. They don't have to. It's completely up to them. And generally, their policy on that stuff is they tend to avoid that, unless it's somebody they really, really want. In which case, they might come out and go, okay, yeah, we were looking for this guy too. But it does help. You certainly want to be advising them of where you're at and what's going on. So if there's any problems, they can be there quickly. A lot of times, they'll send somebody to just park a couple blocks away so they can respond that much quicker if something occurs, but they'll stand off while you do something on your own. But I mean, there are also a lot of, federal civil rights cases. There's a question that how much do we as bondsmen want the police involved in what we're doing as far as picking people up? Because at what point does that make us actual state actors and then subject to civil rights, civil lawsuits against us if we were state actors versus if we're not state actors?
And do you actively bounty hunt yourself, or is it you work with people?
I have not actively bounty hunted in a long time. I mean, that was something I did when I was a whole lot younger. But no, I have people that do pickup work for me. Kansas has a licensing protocol, although it's not particularly strict. It's basically just a background check for if you're not a bondsman and you just want to do bounty hunting work, you have to have a bail enforcement agent's license for Kansas. It costs $200 every 2 years, and it's essentially just a background check to where you don't have any convicted felons or anything along that line that are engaged in that line of work.
I think we got time for one more question. Do you guys have one more question for Shane before we?
My last question, real quick, since we're doing a podcast and you were nice enough to come on and be a guest, what got you started? How long have you been doing it in time, months or whatever? And how often are you doing your podcast?
Well, we're only on episode 4, so it hasn't been a long time. We've only been doing about once a month, and essentially it was a get the message out sort of thing. So how do we put something on I guess digital paper to make these particular arguments? I mean, the viewership on it, hasn't exactly been gangbusters, and a lot of times it's getting this information out to other bondsmen as opposed to the general public. There's a lot of competition in the podcast world for eyes. So I don't know what really got me into it. It was an opportunity that came along. Since I am the legislative chair for our association, they tasked me for getting this set up because they figured I'd be the one that would talk about it best and know the ins and outs of what the statutes are better than anybody else.
How can folks watching this, if they want to tune into your podcast, how can they find you?
Well, you can simply run a YouTube search on Bail in the Midwest, and it's the first thing that will pop up on those search. That's probably the easiest way to do it. Everybody's got YouTube. They can listen to it that way. It is, if you search Bail in the Midwest on any of the podcast sites, Spotify, any of those places, it's there. YouTube's probably the easiest thing to watch or just listen to in the background. I seem like I'm on YouTube all the time anymore, just listening to stuff as I drive. So that's a good place for it to find it.
Well, I appreciate you coming on, Shane, and being a part of our show. Maybe sometime I'll have to come on your show in the future and return the good deed back to you.
Colorado certainly sort of counts as a Midwest. You're getting kind of west there, but the stuff that's going on there, I know that we've been dealing with a lot of the same issues, and you've probably been dealing with them a lot harsher than we have. So I'd love to talk to you about that sometime.
Sounds good. Thanks for coming, Shane, and we'll see you guys next time.
All right, sounds good.
Bail City Bail Bonds, Colorado's premier bail bonds agency. Give us a call today, 970-378-7878.